All right. We're going to skip our gathering song this morning so we can get you guys out of here sort of on time. You know, people are freaking out. Have you been watching the news lately? Have you seen the stories about all of these so-called religious liberty laws being proposed? All these laws that would allow businesses to refuse service to certain people or be exempt from certain laws, supposedly for religious reasons. The one that got the most press recently was in Arizona. Oh, Arizona. Our embarrassing neighbor. The state legislature in Arizona, both House and Senate, had passed a bill which would modify Arizona law so that a business could refuse service to gay and lesbian clients based on the business owner's religious beliefs. People in favor of the law used the example of a homophobic bakery owner being asked to provide a wedding cake for a same-sex couple. Well, they didn't use the word homophobic. They used the phrase deeply held religious beliefs, as in the bakery should not have to make a cake that could later be used in a way that is not compatible with the owner's deeply held religious beliefs. Now, in our society, business owners are not entitled to decide how their goods will be used once someone has purchased them. If we go down that path, it could get pretty crazy. Where would we draw the line? What about other food used in religious rituals? What about romantic greeting cards? What if a mosque wants to buy an air conditioner from a cooling company owned by someone who says that their deeply held religious belief is anti-Islamic? Critics pointed out that the law is too broad and not only discriminated against gay people, but could also be used to discriminate against other groups. And the same kinds of arguments have, in fact, been used for other kinds of discrimination. These days, many of us are too young to remember how religious arguments were also used to fight for Jim Crow laws, for segregation, and for the prohibition of interracial marriages. Under the logic of the Arizona legislation, I could have been denied a cake. Religious arguments were made to prevent women from voting and to protect the institution of slavery. Proponents of these so-called religious freedom laws today are downplaying those possibilities, and instead they're very focused on the three things that they see as the biggest obstacles, or the biggest threats now to their religious sensibilities these days: gay rights, abortion, and birth control. We'll get back to the others in a minute, but in Arizona, the target was gays and lesbians. So it happened that this bill passed the legislature and it landed on Governor Jan Brewer's desk for her to sign into law. Now, Jan Brewer is not known for being compassionate or loving diversity. She's the governor who made news a few years ago for a photo that was taken of her shaking her finger in President Obama's face as she gave him a piece of her mind relating to their differences over immigration, and Obama has deported more people than any other president. Jan Brewer is known for putting teeth behind the idea of reverse immigration, where you make life so painful, dangerous, and deprived for undocumented immigrant families that, in theory, they will self-deport. The theory is that whatever situation prompted the families to leave their homes and communities and risk their lives and their children's lives to cross the border, with a little effort, we can top it and get them to make the reverse trip. And Arizona is the state that banned cultural studies from its public schools, including colleges, a few years ago. No more Latin American studies or African American studies. Can you imagine? That's Jan Brewer. But when this bill landed on her desk, it gave her pause. It turns out that what makes the conservative religious base happy is not necessarily good for the state. By the time the bill made it to her desk, she was hearing a lot of pushback, especially from the business community. There was the threat of a Super Bowl committee boycott. The Super Bowl is supposed to take place in Glendale, Arizona next year. Prominent people in her own party, including Mitt Romney and John McCain, spoke out against it, and even some of the legislators who had voted for this bill did an about-face, saying they'd been rushed and had made a mistake. So she vetoed it. Thank goodness. Now, Arizona isn't the only state to consider a bill like this. Bills about the same core issue have been proposed in at least 24 other states. So far, many have been rejected, either by voters or by legislatures that refused to take them up and move them forward. And none that I know of have been signed into law. But the trend is striking. And not only that, but there are other kinds of religious liberty cases going on right now. In just 9 days, on March 25th, the U.S. Supreme Court is going to hear arguments in 2 cases known as the Hobby Lobby and Conestoga Woods cases. These cases are a reaction to the Affordable Care Act, or Obamacare, which stipulates that health insurance has to cover contraceptives. In other words, the law includes a contraceptive guarantee, meaning that if you purchase health insurance or if you have it provided as part of your compensation package at your job, you're guaranteed to be able to access the health care that addresses the primary concern for women of childbearing age, when and if to become pregnant. Now, when this part of the Affordable Care Act was first rolled out, of course, it caused controversy within Catholic institutions such as universities, hospitals, and charities. We heard about that in the news at that time. So the Obama administration modified the act, and now no churches, religious orders, or religiously affiliated charities have to directly provide the coverage. They fill out a form stating their exemption, then they don't pay for it, you don't have to be involved in it. But their employees can still access contraceptive coverage if it's in accord with the employee's religious beliefs. Many of you will have heard about another Supreme Court case filed by a group of nuns who run a nursing home called the Little Sisters of the Poor. They too were allowed an exemption as a religious nonprofit, but what they objected to was even signing the form. When the news showed the Little Sisters of the Poor, it showed all these smiling little old ladies wearing habits, tending to the patients in their care, but these ladies are about as passive as a pack of Rottweilers. They didn't want to sign a form, and they took that all the way to the Supreme Court. Very tenacious. But Hobby Lobby and Conestoga Woods are a different kind of situation. These are not nonprofit religious organizations. They aren't churches or religious universities. They are 2 for-profit corporations that employ people of different faiths. Conestoga Wood has 2,100 employees. Hobby Lobby has 21,000. But they too are refusing to provide the guaranteed contraceptive coverage. They're arguing that they are morally opposed to the use of certain contraceptives and that the law violates their religious liberty. So in both the Arizona case and the Supreme Court cases, we have people claiming that their corporation or business as an entity is entitled to religious liberty and that they should be exempt from laws that they disagree with on religious grounds. Religious liberty is a core American value, and it's a core value of Unitarian Universalism too. It's represented behind me in our mural, our belief in many paths to truth and our respect for those. The free and responsible search for truth and meaning. When we hear about legislation based on religious liberty, like the one in Arizona, which would allow businesses to refuse service to other people based on the owner's religious judgments, we're uneasy. We know immediately that this feels wrong, problematic. But by cloaking their arguments in the language of religious liberty, the proponents of these laws seem to be engaging our own religious values, our own values. That's why I felt it was important to talk about it from this pulpit today. We're engaged in a kind of political jujitsu, with religious and social conservatives using the language of freedom to constrain the choices of others. It's a critical moment in the struggle for civil rights, and within civil rights, for reproductive rights. The media has made it sound like these cases are about religious liberty versus gay rights, or about religious liberty versus women's health. But that is not what they're really about. These laws in these cases are about for-profit corporations claiming to have civil rights that trump the civil rights of individuals. They are about whether we will have religious liberty for only some people, meaning the owners of businesses, or for everybody. Religious liberty dictates that the local baker and the CEOs of Hobby Lobby and Conestoga Woods are allowed to express their views, but not to impose their religious views on you or on me or on the public. We each have a right to not have their views imposed on us. The baker does not get to plan or unplan your marriage ceremony, and your boss does not get to come into your bedroom. The fact is, religious liberty does not mean the freedom to do whatever you want. The fact is, in order for us to coexist in our diverse society, my religious liberty has to end at the tip of your nose. The law of our land is that business owners can decide what to sell, but they can't decide to sell it only to certain people in society. That's why we don't have white-only lunch counters anymore. And the law of our land is that businesses can't pick and choose which laws to obey. Everybody plays by the same rules because otherwise the playing field is skewed. And suddenly you have women working for disproportionately low salaries for a bunch of CEOs who are disproportionately male, having their access to contraception impeded. Don't get me started. Oh, it's too late. Let's look at it another way. How many of you here this morning would describe yourself as a corporation? No, nobody, right? Corporations don't go to church. They don't light candles, sing hymns, or meditate. In and of themselves, corporations are not entitled to religious liberty because they cannot be practitioners of a religion. Corporations are not people. Same with businesses. We do business. We are not business. Religious liberty belongs to human beings, not corporations. And corporations cannot be equal to individuals because they hold more power than individuals. Fred Getty is a Mormon professor at Brigham Young University, and he's one of many people who have filed briefs in the Hobby Lobby and Conestoga Woods cases. He points out that if the court rules in favor of Hobby Lobby, it is in its essence interfering in religion by picking favorites. It's saying to the corporation, we favor your beliefs over the beliefs of your employees. And this is really important because the implications of these cases go way beyond contraception. If companies can refuse to provide or even allow contraceptive coverage, they could refuse to allow coverage on other health services that they reject on religious grounds. They could refuse to allow blood transfusions, for example, or cancer treatments developed through stem cell technology. Imagine having a hard-to-treat cancer and hearing that your insurance won't cover the best treatment option for you because of your employer's religious claims. And once the health care law has been rejected on religious grounds, what's to stop companies from rejecting other laws they disagree with on those grounds? What's to stop them from firing employees who get divorced or who live together without getting married or anything else they have a religiously framed moral objection to? So if it's not decided wisely, this case could open the door to a landslide of consequences, and it could undermine individual rights. But I'm especially concerned about its impact on women and families. This year, I'm a member of the Faith and Reproductive Leadership Institute at the Center for American Progress in Washington, D.C. There are about 25 of us at the Institute, faith and secular leaders from across the country, who the Center for American Progress brought together in January to kick off a year of study and leadership on reproductive rights. I used to think reproductive rights meant access to abortion. In fact, I applied to the Institute after last fall's abortion referendum in Albuquerque. I was so mad at those out-of-state activists for trying to get in the way of private decisions. So you can thank those protesters for my new, now national level of leadership on the issue. But when I got to Washington, D.C. for our initial training, we spent a large portion of our time on the issue of religious liberty, and in particular, on these two Supreme Court cases that are coming up. Because the thing is that before a woman can make any kind of a meaningful decision about her reproductive health, whether it's to avoid or terminate a pregnancy or to become a mother, she has to have access to her full range of options to begin with. She can't make these choices without the full range of options available. And the real life impact of these cases in which employers want to keep contraceptive coverage away from women, and not just female employees, but their female partners and their female adolescent children, the result of that is that access to birth control is impeded. And the result of impeded access to birth control is more unintended pregnancies, more lives derailed, and more women facing health consequences from not having access to, say, the hormones in birth control, if that is what they need for other health reasons. But where are the voices of women in the public conversation about this? They've been few and far between. We need to speak up with our stories. In fact, I've got a story of my own, where another person's claim to religious liberty threatened to derail or seriously complicate my life. Once, back when I was a part-time student and the mother of a 3-year-old and a new infant, my husband and I experienced a birth control failure. This is more personal detail than I would usually share with you from up here, but it's a relevant story, and it's really important that we get clear about what we're talking about in these cases. We experienced a birth control failure, and I won't go into detail except to say that we knew immediately we were in trouble. I called the midwife who had delivered my son a few months earlier, and she phoned in a prescription for the morning after pill. This was not a prescription for the abortion pill, which causes a woman to miscarry. This was for a dose of hormones to prevent a pregnancy from being established in the first place. And you better believe that first thing in the morning, I got the babies up, fed, dressed, buckled them into their car seats, and I booked it down to the pharmacy to get that thing as soon as it opened. The sooner you take it, the more effective it is. But when I got there, the pharmacist, a big, stern-looking man in his 50s, informed me that he would not fill the prescription for me because he felt it was immoral. If only I'd had a dirty diaper in my hand. I had a mind to launch one right through that Walgreens drive-up pharmacy window. Instead, I informed that pharmacist that I would be filling that prescription. I instructed him to transfer it to the next closest pharmacy 4 miles down the road. And luckily, I had a car. And luckily, my kids were healthy enough to go with me on errands that day. And luckily, I didn't have to hurry into an unforgiving job. And luckily, the next pharmacist did agree to fill it. Because if any of those things had gone wrong, I could have had my 3rd baby in 4 years. And then what? Would I have been able to continue with my studies at community college, which led to a scholarship to a university, which led to admission and scholarship at Harvard, which led me to become your minister? Would I be standing here? I can't say with certainty that I would. And all because a pharmacist disagreed with my midwife's prescription for emergency contraception. That's what we're talking about. His claim to religious liberty did not stop at the tip of my nose that day. It barged right into the most personal part of my life. The Hobby Lobby and Conestoga Woods cases would make that kind of thing much more prevalent. That's the kind of thing we're talking about. Real women's lives, real families. Not religious liberty versus women, not religious liberty versus gays, but religious liberty for a few versus for all. We're talking about access to the marketplace and full participation in society and to essential health care. We're talking about religious liberty that doesn't belong only to people who want to restrict options, but also to people whose faith allows for many options and who want to be the authors of their own lives. As a faith leader, I believe deeply in your right to be the author of your own life. I honor your inherent worth and dignity and your capacity for moral reasoning. I respect that you and you alone know what is best for you. That's why I'm up here. I'm glad I was able to get here. And I'll do what I can to ensure that others, whether they're male or female or gay or straight, can freely pursue their lives and their callings too. I'm going to have us skip our closing hymn and go right to our beautiful postlude.